Hello, good evening. Welcome to our channel Yushi Talks, and today we are talking about Governor DeSantis, who quietly signs controversial condo bill, and owners are already threatening to sue. We have more details. Let's get started. Governor Ron DeSantis on Friday quietly signed a controversial condominium bill into law that unit owners are already threatening to sue over if lawmakers don't fix certain provisions next legislative session. The 154-page bill, HB 1021, is largely about creating more accountability for condominium homeowner associations and managers. But tagged on late in the process this year, there were other provisions from a different bill that gave developers more control over common areas in mixed use buildings, where, for instance, residential units share the premises with a hotel. The bill will become law on July 1st. Mixed use condominium buildings are becoming increasingly popular as retirees look to settle down in buildings run by resorts like prominent hotel brands like the Ritz Carlton, Pearl Harbor, and Carillon on Miami Beach. Combining these commercial and residential developments has created unusual legal disputes over who controls what on the property. Attorneys on behalf of developers argue that it is essential in mixed use buildings for the developer and hotel owners to control common spaces like the lobby, the pool, the restaurants, and the elevators, because they need to make sure that those areas are up to their standards. Stephen Pardo, an attorney who represents condominium unit owners in high profile cases like Miami Beach Carillon dispute, where for years residents and the owner of the hotel and spa have battled in court over who owns common areas, disagrees that developers would keep better care of the property than the condo association, saying that the associations more personally invested in the property, but they often delegate the management of it to licensed professional organizations. Paro also said that he believes that the bill could apply much broadly to even purely residential buildings, giving developers control of everything except for the condo units themselves. But Mark Grant, a real estate attorney and consultant for Hotel Carillon in the Miami Beach dispute, whose idea it was to make the specific changes that were eventually added to HB 1021, wrote to Herald Times in an email that Pardo was mistaken in reading of the bill. The bottom line as to why Mr. Pardo's statement is not correct is that there is absolutely no reason why a developer would want to retain title to or control what is customarily common elements in residential condominium. In a residential condominium, the developer wants to sell all units, and after 90% of the units are sold, the developer wants nothing more to do with the common elements. There is no profit incentive to keep control of them. Operating the common elements is just a burden. Grant said that the mixed use condo buildings under the new law must have a disclosure summary that summarizes the structure and informs buyers that the association will not control the building. Buyers are free to buy or not to buy a unit in this type of product. The issue of who controls the common spaces, the condo unit owners and their associations or their developer, has been at the center of several South Florida lawsuits, which courts recently decided in favor of the unit owners. The late added provisions to HB 1021 could change that dynamic, threatening to append lawsuits still making their way through court cases because it applies retroactively. That's all we have in today's video. Do let me know in comment section your thoughts, your opinion on this. Thanks for watching us. You have a wonderful day ahead. Bye bye.